Welcome everybody to the November edition of our Family Law Brunch, hosted by me, Ayesha Paris, and Esther Lieu. Esther's going to get us started with her talk on Barder and Thwaite, Where Are We Now? Esther has practiced in family law since 2012. She now practices exclusively in private children law and financial remedy matters involving financial provision following divorce or dissolution, as well as separation of unmarried couples. Her financial remedies practice extends across all areas to include appearing in the High Court on applications for injunctive relief and jurisdictional disputes. She's been described as outstanding, supportive, and knowledgeable. And for those of you who regularly attend these talks, you will also know that she's a stickler for the law too. So thank you, Esther.
Thank you, Ayesha, and good morning, everybody. As Ayesha said, my talk today is on applications to set aside a financial remedy order. It's specifically looking, though, at the Barder and Thwaite applications. If I just, try and move slides, here we go. My colleague Rachel Bale, she actually gave a talk in May of this year on applications to set aside more broadly, and many of you may have joined us for that, and if not, then I'm sure the papers are available. As I say, today we're focusing on Barder and Thwaite applications. So being a stickler for the law, I'm so sorry, I'm just struggling with my slides, there we are. Starting off with the Matrimonial and Family Proceedings Act, section 31F subsection 3 of the Act articulates the principle that, subject to the operation of other acts or rules of court, then judgments should be final and conclusive. Subsection 6 operates as the exception to that rule, stating that the family court has the power to vary, suspend, rescind, or revive any order made by it. Those powers are given under section 31F, are given procedure effect by Rule 9.9a of the Family Procedure Rules 2010, Rule 9.9a coming into force in October 2016, and it applies to financial remedy orders only, including those which are made by consent. Those powers are further circumscribed in Practice Direction 9a, and at paragraph 13.5, we see that effectively 4 grounds to set aside are set out. There's fraud, material non-disclosure, and certain limited types of mistake. Those first 3 are sometimes called the traditional grounds. The 4th ground, which we are looking at today, has got 3 components. There must be an occurrence of a subsequent event. That event must be unforeseen and unforeseeable at the time that the order was made, and that event must invalidate the basis on which the order was made. This 4th ground found its strongest derivation in the case of Barder and Thwaite, which is a decision of the House of Lords in 1988. The facts of this case, they're well known, they're very tragic. There was a consent order reached between the parties that provided for the former matrimonial home to be transferred to the wife. 5 months after the order was agreed, but before the transfer took place, the wife killed herself and the children, and the husband sought permission to appeal, as was the appropriate avenue then. Lord Brandon established 4 conditions that must be met before any application for permission could succeed. He says that the new event, or he said that the new event must have occurred since the making of the order. It must invalidate the basis or fundamental assumption on which the order was made, which we then see echoed in 13.5 of Practice Direction 9a. He goes on to say that new event should have occurred within a relatively short time of the order being made, essentially within a few months. Very rare that the event could be more than a year after the order was made. The application by the party seeking to set the order aside should be made reasonably promptly in the circumstances, and the application should not prejudice any third parties who have, in good faith and for valuable consideration, acquired interests in the property that is subject to the application. And in the case of BT and C, more recently in 2021, Mr. Justice Mostyn added a 5th condition, namely that the applicant must demonstrate that there's no alternative mainstream relief available to him to broadly remedy the unfairness. So what cases constitute a Barder event? Is it Barder? For those of you who might have watched Is It Cake? This is perhaps less exciting. But the death of a party. So it's well recognised, Barder and Colliery being the obvious case in point, that the unexpected death of one of the spouses can be a Barder event, but it isn't enough for the other party to show that the party has died unexpectedly. They has to show that the death has invalidated the fundamental assumption upon which the order was made. And what this means in practice, really, is that where the order was made in the circumstances of a needs-based case, then that party may have a stronger case in their application to set aside on account of the deceased party's needs no longer being a relevant consideration. In a sharing case, though, that is less so the case. So, and we see that in the case of Richardson and Richardson, which was before the Court of Appeal in 2014, and most recently in the case of Goodyear and Goodyear. And this is an interesting one because the husband sought to set aside a pension sharing order that had been agreed upon by way of consent order. The wife died 6 months after the order was made. The court accepted that the Barder criteria were met and that the order should be set aside or could be set aside. And it did so, but it in fact replaced it with an order. So the wife's estate, rather than receiving 50% pension sharing order as per the original terms, in fact received 25%. And that's in recognition of the nature of pensions, the hybrid nature being a capital provision and also an income provision. The court recognised really in the circumstances of that case that the wife over the course of the long marriage had effectively earned an entitlement to some of the husband's pension, and she may then in her estate have wanted to pass that on to her children. So her death did not entirely extinguish those provisions of that order. Remarriage, whether that could constitute a Barder event, there have not been any cases, certainly to my knowledge, where that has been successfully argued. There's an obiter comment in the case of Nassim that a remarriage may constitute a Barder event if it was fraudulently concealed from the other party at the time. But again, it would have to invalidate the fundamental basis of that order. Inheritance, again, very few cases. In the case of Critchell and Critchell that came before the Court of Appeal, this was a needs-based case, and again, this is relevant. Pursuant to a consent order, the wife retained the former matrimonial home, which had an equity of about £190,000, and the husband was effectively forced to wait. He had a 45% charge over the property. Shortly after the order was agreed, the husband came into inheritance of £180,000. The wife applied to set aside the original order, and the judge granted her application, finding that the Barder criteria were met. The husband appealed that decision to set it aside, and in dismissing his appeal, Lady Justice Black endorsed the lower court's reasoning that effectively the parties, whilst the assets, it wasn't so much the assets, the change to the assets that was significant, it was the change to the parties' needs. So she did endorse that decision, but she commented that it is nonetheless very rare for a case to come within the Barder principles. One such rare case, perhaps, is the Nassim and Nassim, where the parties again reached consent order on the expectation that they would be sharing the care of their children. But shortly after the order was agreed, the relationship between the mother and the children broke down, effectively leaving the husband with sole care of the children. Mr. Justice Holman granted leave to the husband to appeal. I say appeal because it being a 2015 case, that was the procedure to follow at the time. We all know from the case of Meyerson and Meyerson that changes in asset values from market fluctuations are unlikely to constitute a Barder event. In that case, one of the compounding factors being the global economic crisis of 2008. But despite the impact on the husband's assets, that did not reach a threshold. And similarly, we see from several cases arising from the COVID-19 pandemic, BT and CU being the most well known, that to date, there have been no cases where the pandemic has been seen capable of being a Barder event. The case of BT and CU being the one where the parties had owned and run a business that provided school meals. And as part of the arrangement, the husband retained the company and said on the pandemic, of course, resulting in the closure of the schools, that it was a Barder criteria, it had had devastating financial consequences. The court disagreed, not least because he didn't really evidence his position. But as I said, Mr. Justice Mostyn concluding that the pandemic was probably not capable of being a Barder event. But what if there's been a change in law or indeed in guidance? This brings us to the case of James and Seymour, decision handed down in April earlier this year. This is a decision of Mr. Justice Mostyn, again, as to the appropriate approach to be taken by the courts in assessing a party's child maintenance liability in circumstances where the CMS does not have jurisdiction on account of the payer's income exceeding the maximum threshold. As this seminar is not about child maintenance, I will rattle through the background of authorities. Essentially, in 2019, in the case of CB and KB, Mr. Justice Mostyn suggested that the courts, in such circumstances, should apply the same rate as set out in Part 1, Schedule 1 of the Child Support Act to any income over £156,000 and less than £650,000. This approach was criticised rather, by Mr. Justice Moore in the case of CMX and EJX. Some of his criticisms were conceded by Mr. Justice Mostyn in the case of College Fuchs, and some of his concessions were then approved by Mr. Justice Cobb in the case of RZ. So essentially, this line of authorities results in a dilution, as it were, of the CB-KB approach, resulting in the decision of Mr. Justice Mostyn in the case of James and Seymour. In this case, he accepts the criticism of Mr. Justice Moore. He accepts that the application of the CSA formula would result in figures that were unrealistically high and unhelpful as starting points. And accordingly, he makes an adjustment to the formula that he articulated in CB and KB, providing a new adjusted formula methodology. Now, during this period in which Mr. Justice Mostyn revised his views, the case of De Rene and Galbraith Martin came before him. The facts of this case, it started life as an application under Schedule 1 by the mother, resulting in an order for the father to pay child maintenance for the benefit of the daughter at the rate of just over £1,300 a month. The mother subsequently applied to vary it. The matter came before Mr. Justice Mostyn for hearing in October 2022. He granted the mother permission to seek a variation of the general maintenance on the basis that the father's income was likely to have increased. And at that hearing, he said, "I remain of the view that the guidance in CB and KB is a useful guideline for most cases, and at that level, applying that guideline, his liability for child maintenance would be £2,361 a month." So in December 2022, the parties reached a consent order with the father paying £2,648 a month, and there would be subsequent variations to that figure calculated by application of Part 1 of Schedule 1 in line with the CB-KB guidance. 4 months later, the judgment in James and Seymour was handed down, and unsurprisingly, Mr. Galbraith Martin applied shortly thereafter to set aside the provisions of that consent order and vary them to bring them in line with the James and Seymour guidance. Mr. Justice Mostyn recused himself, and the matter came before Mr. Justice Cobb. He found that there was little doubt that the decision that in James and Seymour, Mr. Justice Mostyn had abandoned his earlier guidelines. The judgment was therefore the subsequent event. It was unforeseen and unforeseeable, and it did invalidate the fundamental assumption on which the order was made. He was satisfied that the father had acted promptly, that the new calculations yielded a significantly different outcome, and that the father had no, or husband had no alternative, sorry, not the husband, the father, he had no alternative mainstream relief available to him. So he set the order aside. He did note that pursuant to Rule 9.9a subsection 5, that he could have at that point inserted his own calculation of the appropriate maintenance payable and disposed of the matter, but he decided to list it for a summary hearing on receipt of written submissions as to the appropriate maintenance award. And that's really the most recent case, and indeed one of the only sort of cases that has dealt with the Barder jurisdiction to date. So moving on to the Thwaite jurisdiction, this is not provided for within Rules 9.9a. It's essentially an equitable jurisdiction. The facts of the Thwaite case, the parties agreed a consent order that the wife would have the former matrimonial home on the basis that her and the children would continue to live in England. But shortly after the order was made, but before the house was transferred to her, she moved to Australia to live with the children and with her new partner. She applied to enforce the transfer of the FMH to her, and the husband applied to vary the orders. Initially, the wife was successful, and the husband's application to vary was dismissed. He took it to the Court of Appeal, who held that her relocation was a Barder event. And in respect of the order to enforce the transfer, the Court of Appeal held that it would be manifestly inequitable to enforce the unexecuted transfer of the property order against him, and that the judge had been entitled, in his discretion, to make a new order for relief in favour of the wife, notwithstanding the fact that the wife did not consent to him doing so. And his jurisdiction to make this new order arose from the fact that the order remained executory. This decision, the Thwaite decision, has been followed in a series of first instance decisions, but its only venture to the Court of Appeal is in the case of Beziliansky, and that is a permission application only, which is not binding. That's relevant, we will see in, as I say, we'll look at now. Firstly, looking at the case of Kaczynski. Notwithstanding the decision of the Court of Appeal in Beziliansky not being binding, Mrs. Justice Lieu noted that the Court of Appeal in Beziliansky comprised of Lord Justice Macfarlane, as he was then. He was the president at the time of the decision in Kaczynski. And she was of the view that their decision carried the greatest of weight. And she confirmed that in her view, the Thwaite jurisdiction is engaged where an order remains executory, that is, it's not fully implemented, and there's been a material change of circumstances, and it would be inequitable not to vary the order. And notably, she confirms in her judgment that there's no requirement, contrary to Barder, that the event be unforeseen or unforeseeable, or indeed that the event invalidates the basis or fundamental assumption on which the order was made. Now, as I alluded to, the Thwaite jurisdiction has it's controversial. The most notable detractor is Mr. Justice Mostyn. He has certainly in 2 reported cases expressed his clear discomfort with the suggestion not so much that the court can refuse to enforce an order, but that under the Thwaite jurisdiction, the court can go beyond that and in fact rewrite an order, even in the absence of the party's consent, which is why in the case of SR and HR, said that the court should approach this doctrine cautiously and conservatively. In the case of BT and CE, he acknowledged that after the case of SR and HR, there had been 4 further cases, all of which dismissed his doubts as expressed in SR and HR, and all of which upheld the Thwaite jurisdiction. But he remained of his view that Mrs. Justice Lieven's decision in the case of Kaczynski was in conflict with the binding precedent of Barder. More recently, we have had the case of H&W that came before Her Honour Judge Reardon. In this case, we have a consent order between the parties, providing inter alia for the wife to transfer to the husband 3 investment properties and for the husband to transfer the former matrimonial home to her. The matter came before Her Honour Judge Reardon on the parties' cross applications, the husband's case being that the wife had refused to authorise and engage with the marketing of the sales, she had frustrated the transfer of the investment properties, she had granted new 12-month leases in respect of them, she had remortgaged one of them, and in fact voluntarily surrendered one of them to the mortgage provider. He applied under the Thwaite jurisdiction for a further lump sum to compensate him for the losses that he said he suffered arising from the delay in the transfer of properties, arising from the wife's further borrowing against one of them, and arising, as he says, from the fact that one of them had to be sold at a undervalue. He also applied for enforcement of an order for periodical payments to prospectively enforce any lump sum arising from the periodical payments and their arrears, and for there to be a charge against the property and a default order for sale. All those applications, or both those applications, have been brought under the Thwaite jurisdiction. Her Honour Judge Reardon, she considers the criticisms raised by Mr. Justice Mostyn and acknowledges that the jurisdiction is controversial. But she then observes that there is usually a close link between the executory nature of the order and the disaffected spouse's ability to frustrate it. It's particularly obvious in property sale or transfer cases where, however tightly drafted the order is, the owner of the property still has a number of opportunities to obstruct and delay the transfer or diminish the value of it in the pre-implementation period. The Thwaite jurisdiction would appear to be the only remedy available in such cases, where the change in circumstances has been brought about by a foreseeably disaffected spouse rather than an unforeseeable event. She then concludes that for these reasons, it's my view that the Thwaite jurisdiction does exist as a separate remedy to Barder, and that it may be particularly apt where the respondent has culpably acted in such a way as to diminish the value of an asset, that there might be a link between the executory nature of the order and the change in circumstances, i.e. the order has remained executory because the party has frustrated its implementation, and the applicant in such circumstances may in fact fail the first limb of the Barder test because the respondent's conduct was in fact foreseeable. And she notes that the essence of the Thwaite jurisdiction is one of fairness. So she goes on to order that, or to find effectively that the husband had suffered a clear and quantifiable loss due to the wife's conduct, and that compensation was only available under the Thwaite jurisdiction, and indeed made various orders to compensate him for the loss that he had suffered as a result of the delay in transfer and the reborrowing and the sale of one of the properties for an undervalue. She agreed to make an enforcement order for the periodical payments with a charging order to secure the sums for the default order for sale. Again, that coming under the Thwaite jurisdiction, being beyond what the original terms of the consent order had provided for, and being not contrary to the wife's consent. The husband sought his costs of about £42,000 on an indemnity basis. The court considered that her conduct was not so egregious and awarded them on a standard basis, with the wife being ordered to pay around £30,000. The last case to look at is the case of AFW and RFH. It's a decision of Recorder Moyes, again in respect of transfer or sale of a property. The husband was found to have breached several provisions of an order providing for the sale of the property. He had refused to cooperate. He had spat at an estate agent. He did not engage with the wife's correspondence, did not complete pension sharing annex, and the wife applied to enforce the order. The husband invited the court, in fact, not to enforce the order on the grounds that it would be inequitable to do so because the value of the property had fallen, invoking the Thwaite jurisdiction. The court found that, notwithstanding the fact there was no evidence that the value had fallen, nonetheless, the fluctuations in the property market was not a significant change, and nor would it be inequitable in this case to enforce the order. And on this case, costs were awarded to the wife on an indemnity basis. Turning and concluding, therefore, with some practicalities if you are minded to make an application to set aside an order under that fourth ground, either under a Barder application or Thwaite. The procedure set out in Rule 9.9a, Practice Direction 9a, it's a Part 18 application using the Form D11. Make the application to the court who made the original order, same level of judge, ideally the same judge. And on an application, the court has got the full range of case management powers. It can strike out or summarily dispose of the application to set aside, or if it does decide to set aside part or any of the order, it can give directions for a rehearing or any such orders, including disposing of the application there and then if it considers it's got sufficient information. The costs rules, it's a clean sheet approach when the starting point being that costs follow the event, as we saw certainly in the last two cases. So where are we now? Has anything changed? Barder events they remain extremely rare. The case of Richardson and Richardson, albeit a 2011 case, but Lord Justice Thorpe saying that cases in which a Barder event, as opposed to a vitiating factor, can be successfully argued are extremely rare. They should not be regarded by the profession, or they should be regarded, I apologise, as exceedingly rare and are not thought to be extendable by ingenuity or the lowering of a bar. Thwaite, it is certainly less clear-cut. Is Thwaite just an equitable jurisdiction whereby the court can refuse to enforce an executory order, or does it extend beyond that and enabling a court to in fact make a different order? The case of H&W that we've just looked at, held by Judge Reardon, arguably it makes Thwaite's applications more accessible, but it is of course just a decision of the lower courts, and therefore we remain somewhat in limbo until a Thwaite application makes its way through to the Court of Appeal. That brings my talk to a conclusion. I hand you over to Ayesha now. She's going to talk to you about concluded agreements. Ayesha was called in 2012. She's based between our Birmingham and Oxford centres. She practices in a broad range of family matters, specialising in financial remedy and private children cases. She's renowned for her impeccable preparation of cases, outstanding written work, and a very sensitive and pragmatic approach, which has been commended by lay clients and judges alike. Thank you.
Thank you, Esther. Just share my screen. Hopefully the technology will work. Yes. There we are. I should have said that we welcome questions during our talks. Please make those via the chat box at the bottom of your screen, and we'll do our best to answer those at the end of the talks, and also that our slides will be sent to you. So good morning. I just wanted to talk to you about concluded agreements and a bit of a recap on those. It's something that I know do crop up in a number of our cases, and I thought it would be helpful to look at some pointers as to what we need to be thinking about when advising clients about whether such agreements should or could be relied upon or set aside. So to start off with, just looking at the fundamentals as set out in Radmacher and Granatino. I won't go through those all in detail, but I've put them on the slide. But effectively, we know that the court should give effect to a nuptial agreement that is freely entered into by each party with a full appreciation of its implications, unless in the circumstances prevailing, it would not be fair to hold the parties to their agreement. So I've set them all out here that you can have a look at. And I would say really there are three questions one has to consider broadly. The first two being factual matters and the third being a legal matter. So firstly, was there an agreement reached? Even if there is a consent order that's not signed, the courts have of course found that an agreement can be reached, or even if the agreement itself contains a term that it remains open to further discussions between the parties before final agreement, and we'll touch on a case where this happened in a moment, the court can still find that it binds the parties. Of particular importance is the extent to which the terms have been implemented and the parties have relied upon it. The second factual test is whether any of the vitiating factors are present: duress, fraud, or misrepresentation. And of course, even whilst those will negate any agreement, unconscionable conduct such as undue pressure that falls short of duress might still eliminate the weight to be given to the agreement. And then the third step, I would say, which is a legal consideration, is in the circumstances, is it fair to hold the parties to the agreement? It's needs and compensation really that the court looks at in this sphere. Applying the Section 25 checklist, does it leave one party in a predicament of real need? And we'll touch upon that more later in this talk. So I thought, firstly, it might be helpful to have a look at the idea that each party needs to have all of the information that is material to their decision. And in my experience, it can be quite tricky if you have a client who turns around and says, well, at the time I agreed to this, I thought the property or company was worth X, and actually it turns out to be worth Y. Is it incumbent on each party to make sure that they have obtained valuations and can satisfy themselves with those before they reach the agreement? Or how far does buyer beware go? As always, the case law tells us that these are very fact specific, but just looking at a couple of cases, the first is the case of Horoho and Horoho, which is a 2020 decision of Mr. Justice Holman. The facts of this case were that it was a 16-year marriage. There was a post-nuptial agreement made 2 years post-separation. It involved the transfer of properties and involved the husband retaining 2 companies that he operated as a carpenter and property developer. At the time, both parties believed that the companies were effectively worthless, although neither got any valuations. The agreement was then drawn up into a document, and this is the case where the wife took the document to a solicitor who advised her not to enter the agreement without the proper valuations, but she chose to proceed in any event. And effectively, the agreement itself contained provision that this proposal has been prepared following meetings with both parties independently, and is of course still open for further discussion amongst the parties pending final agreement. So it had that term in it that effectively it wasn't final, it was open to further discussions, but the court did find that it was binding. Effectively, because the parties had implemented the terms of the agreement over the following years. Mr. Justice Holman found that effectively he didn't find exactly when it became final, but effectively the fact there hadn't been any further discussions and the fact the parties have implemented it, he said it had become final prior to the wife's subsequent financial remedy application. But anyway, I digress about the agreement itself. But turning to the information the parties had, as I said, the wife solicitor told her not to agree to it without the business valuation. She went ahead anyway. And over the next years, the order was implemented. Wife received properties with a total value of circa 1.82 million and the husband 1.14 million. And the wife, 7 years later, petitioned to divorce and made a financial remedy application. And she claimed that the agreement reached was neither fair nor binding because the total pot was now worth over 10 million. And much of that was made by the husband's companies, which had expanded considerably since the negotiations. And the wife then sought a further 5 million capital contribution from him. The wife claimed effectively that the husband had cheated her at the time of the separation and provided erroneous valuations for the company. So Mr. Justice Holman effectively found that the contention in 2012 that the company was worthless was incorrect. It was concluded that at the time of separation, the value of the company was in fact at least 1.5 million, of which the wife ought to have received a half share. But Holman J did not consider that there had been a deliberate misrepresentation or fraud on the husband's part in stating that it had no value. Effectively, he concluded that the husband had been genuinely mistaken as to the true value. Now, the wife had also raised issue about the valuation of some of the properties that the parties had owned that had been transferred. And Mr. Justice Holman considered that it simply was not open to her to now assert or object that unfair or erroneous property valuations were used. And that was on the basis that these were properties that she was familiar with. She certainly knew exactly what her own home had cost and the extent of the works or improvement and enlargement done to it. In other words, she had a rough idea of how much these were worth. And as I said, it's buyer beware. But the court did find that different considerations applied to the treatment of the companies and the assets within them. And that's on the basis that the wife had no active involvement in the companies for several years, although she had, as the company secretary, signed the annual accounts and seen those. But effectively, the court considered that she cannot reasonably have been expected to have had any informed personal knowledge about the value within the companies at the time, which she jointly owned. The court did consider the weight that should be taken against the wife in terms of the fact that her own solicitor had advised her very clearly that she should obtain a valuation for this company before agreeing. But ultimately, the court considered that the very fact the wife had sought the advice of her solicitors, received that advice, but then did not seek any formal independent valuation of the company, actually only served to underline the extent to which she trusted and relied on her husband on the issue. So the court was effectively satisfied that in her mind, she had established the value of the company because her husband had told her it and she had trusted him. So effectively, it was reasonable for her to do so. So in those circumstances, the court did say that at the time the agreement was unfair because the wife hadn't had all of the information. The value of the business was completely wrong. And he did order her a further £600,000 lump sum in order to remedy that. He took off a slight discount for the fact that effectively the wife had retained the properties, which were a safer investment than the business at that time. So that's an interesting one in terms of how far parties need to go in terms of conducting their own inquiries about the value of the assets at the time. So what about if there has been deliberate misrepresentation or non-disclosure? Should the court be restricted to remedying the part which relates to the non-disclosure only, or should the court approach the case with a clean sheet? There's a case of Goddard-Watts and Goddard-Watts, which is Lady Justice McCure this year, which is effectively, again, a post-separation agreement drawn up into a consent order. This is an unusual case in that there were two separate occasions. Firstly, when the original consent order was drawn up, and then on a second occasion and set of proceedings, the husband had misrepresented his assets and had failed to make appropriate disclosures of significant capital accumulations that he would have in the foreseeable future. The first instance judge decided he was not going to start from scratch effectively, but took the Kingdon approach from the case of Kingdon and Kingdon, which is authority for the principle that the court retains a wide discretion to adapt to isolate the issues to which the non-disclosure relates and remedy those without dismantling the whole agreement. The judge restricted his consideration to the non-disclosed assets, leaving the rest of the award as it was. He made an additional award based upon his assessment of the wife's needs, rather than starting with a clean sheet. And the reason he did that was he said that effectively the single issue in the case was now the value and realisation of the husband's shares in his business. And effectively the remainder of his disclosure at that time the time of the agreement was uncriticised. The wife's appeal then centred on the judge adopting that Kingdon approach, and she said that the court should conduct a fresh investigation into the husband's financial matters to make sure there was a fair outcome and to ensure the husband did not benefit from his fraudulent behaviour. The wife argued that she should have her claim fully and fairly determined in 2022 based on the actual and real-time financial landscape, even if that was subject to post-separation accrual. And she relied on a civil case of Takar, which she said overruled Kingdon approach, effectively that if the judgment's set aside, then you start from scratch. Well, Lady Justice McCurr considered this and disagreed that the Takar approach, which is that civil approach, overruled Kingdon. And she said that in family proceedings, we don't separate between issues of liability and quantum. Kingdon's discretion is hugely fact-specific, and Lady Justice McCure therefore refused to suggest any guidelines for the applicability of it, save for noting that in Kingdon itself, that approach was appropriate because it was the non-disclosing husband who had sought to benefit from the fraud by setting aside the whole order to his advantage. And in that case, the restrictive approach had protected the wife. But in the instant case of Goddard-Watts, Lady Justice McCure found the judge was wrong to adopt the Kingdon approach because it could not be confined to a single issue. One of the reasons for this was the additional contribution that Mrs. Goddard-Watts had made to the welfare of the family and supporting the children who were all estranged from the husband. So Lady Justice McCure took the view that the husband's misconduct constituted, under Section 25(2)(g), a glass through which the other factors in the case should be considered. And the wife should therefore be entitled to make her case on a blank page basis. So I think it's really important when you're looking at cases where there has been deliberate misrepresentation or non-disclosure to try and consider about precisely what that goes to. Is there an argument to say that it should only be that aspect which should be reevaluated? Or can you make an argument if you're for the party to seeking to say that effectively the whole amount should be now re-looked at and the whole award, on the basis that it's fundamentally unfair? Now, I thought moving on, it would be helpful to look at cases where one party attempts to go behind an agreement by asserting that they were under undue pressure. I would suggest that the case law tells us it's quite a high bar to persuade the court that there has been such undue pressure. One such case is the case of WC and HC of Mr. Justice Peel. This case involved both pre and post matrimonial agreements, and the majority of the wealth in this case came from the husband's parents. The parties were married in 2004, entered it into a prenup that was signed 3 weeks before the marriage. very much at the instigation of the husband's father. During the marriage, the mother had moved to live with the husband in Switzerland and their children, the wife. In 2015, she then wanted to return home back to the UK with the children. In the meantime, the husband had also become the discretionary beneficiary to a trust which contained £23 million from his father, but that was subsequently reneged effectively when these proceedings were issued. There was agreement to the wife returning to the UK with the children, but it was on the basis that the husband had raised the need for a further postnuptial agreement in 2017. And on the evidence, Mr. Justice Peel was satisfied that the husband had told the wife she could not go to London without signing this new agreement. In doing so, he threw into doubt the London schooling arrangements for the children which were in place. And he also told the wife that he would only agree to having a bigger house if she signed the agreement. So the wife subsequently agreed to its terms in correspondence, but did not sign it. She ultimately declined to do so. And that postmarital agreement had specified that it would only come into force upon the date at which it is signed by the last of the parties. So effectively, the wife's case was that there was pressure both in terms of the prenuptial agreement in 2004 and also the later agreement in 2017, and also effectively that the agreement was unsigned. Mr. Justice Peel didn't accept the arguments for either of the pressure points. He considered that effectively pressure to sign or there will be no wedding is not a particularly unusual or compelling factor, and perhaps inherent in any prenuptial agreement that will be the case. I'm conscious that quite commonly clients will say to us they felt under pressure to sign agreements because they either needed the money that the order would provide and they were the financial weaker party, or they were emotional at the time, or they felt they were subject to a certain level of coercion or control. In my view, fairly robust advice needs to be given about the high bar that's required in order to prove undue pressure. So in WC and HD, Mr. Justice Peel said he was satisfied that both parties were under pressure, but it was not undue pressure. And effectively, he goes on to say that in almost every pre or post-nuptial agreement, one or both parties are under a high degree of pressure and emotions may run high. But effectively, he found that unless there's undue pressure, that the court must accept that there will be tension and disagreement, and effectively each party has to make a choice. So it is a high bar, as I would say, and in neither of those cases, either the prenup or the postnup in 2017, was there undue pressure. In terms of the fact the agreement wasn't signed, the judge did consider that in absence of the signature, in circumstances where the wife had consciously decided not to sign, it did take the agreement outside of the Radmacher category of cases, but it did still fall to be considered as one of the factors in the case, but it wasn't presumptively dispositive as it would have been if it had fallen into the Radmacher category. So the award that the court made of £7.15 million was broadly in line with what the wife would have received under the unsigned 2020 prenuptial agreement, the post-nuptial agreement, which he noted the wife had not appeared to be unhappy with in quantum at the time. So what does it take for the court to be satisfied there has been a level of undue pressure or influence? We can look at a 2022 case, SC and TC, of His Honour Judge Hess giving judgment. Effectively, this was a long marriage whereby the husband was unfortunately diagnosed with Parkinson's disease. There were marital problems about 20 years into the marriage, as a result of which the husband visited a sex worker. The wife wished to end the marriage and agreed to only remain married if the parties entered into the post-nuptial agreement, which she drew up in 2014. This provided for her to receive 80% of the assets, which was significantly more advantageous than it would have been if determined by the court. The husband in that case was strongly advised not to sign the agreement, but did so anyway. He stated it to his solicitor at the time, given my Parkinson's, it makes no sense for me to have any assets in the long term, and noted he would rely on care provided by the local authority. The parties then separated in 2020, and the following year the wife issued a notice to show cause, seeking to effectively rely on the terms of the agreement. In the decision, His Honour Judge Hess concluded that no weight should be placed on this agreement, as doing so would be unfair. He concluded that the husband was vulnerable at the time of the agreement was signed, having been diagnosed with Parkinson's 3 years earlier and suffering from depression. he found that the wife took advantage of the husband's vulnerability to gain financial advantage, and that enforcing the agreement risked leaving the husband in a predicament of real need, possibly leaving him in inadequate accommodation, or running the risk that he would have no option but to go into a care home when he was clear he wished to remain at home by that point. So effectively, Honourable Judge Hess decided that the parties' assets should be divided equally, as was sought by the husband. And there's a quote on the slide effectively as to his sort of thinking in this. And he considered all of the circumstances as they affect each other of two human beings in the complex relationship of the marriage, effectively deciding that the agreement was not a fair one. So that's the sort of circumstances where the court might find there's been an undue level of pressure and vulnerability. And finally, just touching really about the interpretation of predicament of real need, because there's been some guidance given in case law this year. HD and WB from March of this year by Mr. Justice Peel again. This was a case with a lengthy cohabitation of about 15 years. The prenuptial agreement was actually signed on the day of the wedding, and the wealth in the family came from the wife's family trust, which exceeded 43 million. The husband was a significantly weaker financial party. The wife had offered the husband a sum of 362,500, which effectively is what she says he was entitled to under their prenuptial agreement. And the husband sought £8 million advanced on a needs basis. Mr. Justice Peel considered whether the husband was left in a predicament of real need with the 362,500. The wife argued that all that needed to be done was to make sure that he was not left in destitution, whereas the husband argued that effectively, once the court finds that the husband is in a predicament of real need, it then opens the gateway to the Section 25 criteria to reassess his needs generally. So kind of generous interpretation of needs. And Mr. Justice Peel said, effectively, I take the view that whether a party should be confined to needs at the minimum level required to meet a predicament of real need will depend on the circumstances of the case. There is a world of difference between, say, a childless couple whose marriage lasts for 2 years, enjoying a modest lifestyle, at the end of which one party might need no more than a short-term maintenance or a highly attenuated housing budget, perhaps limited to time-limited rental, and two, as here, a couple with 3 children who have been together 20 years, who each contributed to the welfare of the family in different ways and enjoyed a high standard of living. So he did not agree with the approach of the wife, that effectively he thought to be too straitjacketing, that it's just destitution, but equally he didn't consider it was as generous as effectively that 2-stage gateway and just assessing all needs once you've opened the doorway of a predicament of real needs. So he said in the right case, a minimal award to meet basic needs may be appropriate, but it will depend on all the factors, including the agreement, the resources, length of the marriage, the decisions and the lifestyle. In that case, the ultimate order provided the husband with a total of about 1.9 million, which was only 4% of the liquid wealth, plus a housing fund, but that was subject to the wife's revisionary interest. Interesting, had the parties married without that prenuptial agreement, Mr. Justice Peel suspected that the wife's award would have been significantly higher, but it was said that that decision reflected a proper recognition of the limiting consequences of the postnuptial agreement balanced against the Section 25 criteria. And finally, Cummings and Fawn, Mr. Justice Mostyn, just because as a previous English literature student, I quite enjoy the kind of visual of this description. But effectively, he considered some reasoning he'd previously given in the case of Pecky and McConnell into 2019, where he'd said, I do not take the language used by the Supreme Court, namely a predicament of real need, as signifying that needs when assessed in circumstances where there is a valid prenuptial agreement in play should be markedly less than needs assessed in ordinary circumstances. If you have reasonable needs which you cannot meet from your own resources, then you are in a predicament. Those needs are real needs. So effectively a very generous interpretation at that time. But in the case of Cummings and Fawn, he reflected on this and said, on reflection, I do not consider this was at all well expressed by me. And then he goes on to talk about his bookends effectively, that you imagine the discretionary reign is a line of books on a shelf bracketed left and right by bookends. The bookends might be quite far apart. The right bookend represents a comfortable, perhaps even luxurious lifestyle. The left bookend represents a Spartan lifestyle, catering for not much more than essentials. The space in between is the discretionary range. When the Supreme Court says that it may not be fair to uphold an agreement which leaves the applicant in a predicament of real need, it is clearly saying that if the result of the agreement would place the applicant in a standard of living to the left hand of the left hand bookend, then it would be unfair. It is also saying that to make the agreement fair, it should be augmented by no more than is necessary to move the applicant's lifestyle just to the right of that left-hand bookend. So again, I think it's quite a kind of a good description of how there is this room for argument between these left and right bookends. So I think there's still more guidance to come about predicament of real need, and it's certainly something that there's scope for advocacy and scope for argument about what that needs when dealing with these cases. So the takeaways really, I would say, is that it's always useful to remember that for a notice to show cause application, of course, costs follow the event. So there's a real need when advising parties seeking to rely on these or to depart from consent orders, that we really ensure a proper review of the evidence and the prospect right at the outset with some robust advice before parties embark on these proceedings, which can become very expensive and do involve a huge degree of risk by their nature because of that cost element. So that's really my sort of takeaway and word of warning about these cases, really. But it's now time for some questions and answers. So I will just bring my screen off.
Ayesha, thank you very much. We do have a few minutes left, and we will take a couple of questions. If we aren't able to respond to your question in the remaining time, which we probably won't be able to cover all of them, then I'm sure Ayesha and I will be able to find time over the next few days to get in touch with you personally. I've had one question that's come through just now. It's about, to summarise, I think the question, there was a final order at a final hearing whereby the husband was found to, or he was he was a director of a business along with a partner. His 50% share was worth £200,000. A needs-based case, the business was the only asset. The court ordered, from what I'm told, that the husband pay the wife a lump sum of £100,000, effectively 50% of his interest. And I understand there were additional comments in the judgment about it being a needs-based case and also one where there were limited resources. And shortly afterwards, perhaps 4 months, I think, after that final order, the husband's business partner transferred his share of the business to the husband, so that the balance, the remaining £200,000, and that the husband therefore has sole control of the business. The question being, is that a Barder event? Obviously, I can't advise in terms of black and white, and would need to see a lot more in terms of what the parties' assets were at the time, and more provisions in respect of what disclosure. But it seems to me, and there's two things to look at. I think there'd be one avenue would be looking at whether it's a case of material non-disclosure, and therefore would need to ask some more questions as to what the husband knew at the time of the final hearing, whether there had been any conversations between him and his partner, whether there was any evidence to suggest that this payment was envisaged by both parties, and that it had been deliberately deferred pending the conclusion of the financial remedies proceedings, in which case this would be an issue of material non-disclosure, and an application to set aside could be made under that. I think if an application is to be made under Barder, I mean, the authorities are clear really that the biggest stumbling block is whether the event is unforeseen and unforeseeable. It has to be both. It can't just be unforeseen, it has to be unforeseeable. And the courts take quite a stringent approach to that. It is a very high threshold. And I think I would need to see, say, more evidence about the circumstances of that particular case to see whether the transfer of the business partner's share to the husband was really that unforeseeable. But that's my take on that. I've got another question. It's a bit linked. It's whether in circumstances somebody could make an application under sort of Barder and Thwaite, sort of seeking relief under both jurisdictions. I mean, there's no reason why you can't, but you'd have to be sure that the facts of your case fall or meet the criteria established in both cases. That said, the case of Thwaite itself, in fact, the wife's relocation to Australia was a Barder event, and then the Thwaite jurisdiction evolved from the issue about the enforcement of the order for the transfer. So it can happen, but they're different tests. As we know with Thwaite, there's no need for the event to be unforeseen. There must be a degree of inequitability in the view of the court as to whether an order should be enforced or not. The Thwaite jurisdiction extends in terms of the court's power as it stands to make fresh orders. So I think you need to be very clear about what you are seeking and why. And there's different risks, I would say, in bringing an application under either. I think there are fewer risks. I say that notwithstanding the fact that there are, of course, the costs rules to be mindful of. But Barder is a decision of the House of Lords, as it was. That is binding precedent, and provided your case sort of fits within those criteria, then you are arguably on safer ground than we are with Thwaite, as we've seen from the decisions of Mr. Justice Mostyn and the discussions thereafter. I think with Thwaite, you are perhaps very much more in the hands of the court and their discretion as to how they want to exercise their power. So it would, again, depend on the circumstances of your case in particular. I will hand over to Delphine to see if she's able to respond to any.
That lots of questions. I'll try and deal with some of them. I'm conscious we've not got much time left, but I will try to respond to all of them after the seminar if possible. So first of all, are there circumstances where an agreement reached between the parties through solicitor negotiations, albeit with a significant imbalance in favour of the husband, can be varied if the consent order has been refused by the court for that reason? I've had this in a recent case, actually, but the court hadn't actually refused it, but had asked for some more information that hadn't been given by the parties, and they'd implemented it then. But effectively, if the parties know that this isn't an agreement the court is going to approve, then there will have to be some level of renegotiation if they want this to be a formally approved consent order, because they already know what the ultimate outcome will be if either of them sought to rely on it again. Effectively, that it's already been found by the court to be unfair. So effectively, there wouldn't be much benefit to trying to rely on it in circumstances where they know the court had rejected it. So there would be scope, in my view, for some renegotiation about that. I think it's different if the court's asked for some further information or called a hearing in order to discuss and hear submissions about whether it should be made final and whether it is fair. And I think in those circumstances, there's a case to really try and stick to the agreement and not renegotiate further. But I think if the court's actually refused it on the basis that it's not fair, then there will need to be further renegotiation. I also have another question. What about if the evidence needed to prove that the agreement was reached, or, for example, that there was misrepresentation, comes from mediation and is contained in mediation notes or without prejudice correspondence? Well, I think interestingly, we see, mediation, we think not, without prejudice, we can't rely on it, we can't put it before the court. But actually, there is authority within civil cases to say that the without prejudice communications can be admitted into evidence where it's necessary to determine whether those communications resulted in a concluded settlement, or whether there's been an instance of misrepresentation or fraud or undue influence. That case is Brown and Rice and Patel, 2007, EWHC 625. But effectively, you can ask the court to delve into those mediation notes and apply for them to be disclosed in circumstances where you need them to prove your case on whether an agreement was reached or whether there had been misrepresentation. So I think that's worth remembering. I don't know, it's 12 o'clock now, so I'm not sure whether we've got time to answer any more questions, but.
I think if we leave it there have been some more coming in the Q&A. Thank you for those. We're delighted that you've stuck with us and engaged with us. We will make a note of all of those questions. Very happy to respond to them in due course. Equally, if you'd like to contact either of us directly through Chambers with any additional questions, then you are very welcome. Thank you again for joining us. We are returning, I think, on the 25th of January. So put that in your diary. The topic has yet to be confirmed. I'm fairly sure again that we welcome suggestions for topics that you would like us to speak on, and we can take those into account. But put the 25th of January in your diary, and we wish you all a very merry and festive Christmas season as well. Thank you for joining us. Bye.